Okay, very good evening all. Am I audible?
Yes, sir.
Yes, sir. Yes, sir.
All right. Good evening, Mr. Chauhan.
Good evening, sir.
I'm glad few people joined. All right. So we are tight with the time and the schedule, and since this is the last session or the chapter of the series, we are going to keep it quick, to the point, and we'll end sharp at 7:30 because I have to catch a train at 8:30 to Allahabad again. So now today's topic is 482. All right. 482 is a very, 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 very vast and a big number in criminal jurisprudence. It encompasses almost everything what you can think of. If you have experience of filing a 482 petition in High Court, then I could give you a little more knowledge about its scope and what you can do about it. Okay. To begin with, 482 actually is a marriage between Article 2 to 6 and 2 to 7 of Indian Constitution. Okay. So Article 2 to 6 basically has 5 kind of writs, which is mandamus, certiorari, quo warranto, prohibition, and habeas corpus. 2 to 7 is the superintendent's power of a high court over the lower judiciary per se. Okay. Now, those who are listening can unmute themselves so that it's a little bit of an interactive session if your background is quiet, and those who are not listening may not. So it's a combination of when the legislation made 482, hello Mr. Chopra, made 482, they basically picked up both these sections and they wrote it in CrPC. Now, if you compare it with the CPC, CPC is 151, which even a second class magistrate has power. Not a second class, I mean, say a junior civil division junior judge also has power to use 151. But that's not the power which a magistrate or even a session court has. So it's a very sensitive power, and legislation only wants high court judges to use this power sparingly. That's the whole idea. If somebody has CrPC with them, and may just quickly read what Mr. Chauhan has it, if you can quickly read what 482 CrPC says.
CrPC 482, saving of inherent powers of High Court. Nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice.
All right. So these 3 points are very important. Just note these 3 points in your diary. First one is to give effect to any order, correct? Under this code. Second one is to prevent the abuse of process of court, correct? What is the third one, Mr. Chauhan?
To secure the ends of justice.
To secure the ends of justice. So basically, these are the 3 most important sentences which covers the entire 482. First one is effect to any order. That also includes the execution of any order which has been made under the code. That order should be actually effective. It should make some sense. It's not that it's just in the papers. That order should make some sense to the person in whose favor that order has been passed or against that order has been passed. So if that order, if it's not an effective remedy or if it's just an ostensible remedy, then you can invoke 482. Prevent the abuse of the process of the court is when people are actually abusing the law. for their malafide reasons, for whatever hidden agendas they have. The classic example is these fake FIRs which are registered in crime against women. So if the landlord wants to evict the family, and the family is already not so decent because they do not want to evict the house, or they don't want to pay the rent or whatever they want to do, the wife will try to invoke 354 against the landlord. Oh, he came to my house and he tried to disrobe me and so on and so forth. And CrPC, IPC says that, okay, it's mandatory for the police to register an FIR in 354 without any doing background check. You know, the rape allegations, the 498A, so on and so forth. So these are very common classic examples where which falls in the category of abuse of the process of court of law. Or you're maliciously instituting a case where you do not have locus standi, it's a vendetta. All right. Then to secure the ends of justice. Also, High Court can invoke its powers to secure the ends of justice when the justice is not done. The classic examples would be where reinvestigation is one such example, where you're wanting the matter to be reinvestigated because the police did not do their due diligence. You know, you could be a father of a deceased person, you could be a father of a rape victim, so on and so forth. The other party is a rich party. They bribe the police, and police is not doing anything. They just filed a frivolous charge sheet. You know, they did not do their forensics properly. They did not do a lot of things. You could approach High Court and you can say, look, your investigating agency should be changed. My investigation should be redone, so on and so forth. That's when you invoke 482 to secure the ends of justice. Reinvestigation is one classic example. Further investigation, magistrate has the power to direct further investigation under 156, but reinvestigation, it's only High Court under 482. There's a difference in reinvestigation and further investigation. A lot of other areas where we need to secure the end of the justice and we invoke 482. This is from the Bare Act. Okay, these three sentences are from the Bare Act. Now, if you move how the jurisprudence has evolved in 482, few examples are petition to expunge remarks. So can somebody tell me what do you understand by expunging remarks? What kind of petition would that be? Whose remarks you want to expunge? Which could hurt you? Mr. Chopra, you want to give it a shot?
It must be
Remarks
the
that can be
opposite.
removed or that one needs to be removed.
I'm sorry, Saurabh?
Remarks that needs to be removed that can hurt our case.
Absolutely. So a classic example would be, thank you. A classic example would be while dismissing the bail application, a judge went beyond the observations of the police, judge went beyond the scope of the bail application, so on and so forth, and gave certain remarks which could prejudice the mind of a successor judge or your entire case. All right. So if something has been recorded, which is not the case, or which is beyond the jurisdiction of the judge who has recorded, or for instance, they have recorded misbehavior, misdemeanor of a counsel, when actually it's not a case, it's an enmity between a magistrate or a sessions judge and a court counsel, and they write certain things which are not required. Then you go to a higher court and say, look, this is not the case and these remarks should be expunged. So that's when you can invoke 482 CrPC. A second most widely used way to quash an FIR is 482. So petition to quash an FIR, complaint, or an order of a cognizance. So these three are the categories So an FIR per se, at the stage of the investigation, so once the FIR is registered till the 173 is complied with, that means filing a final report, the FIR can be quashed. Okay. Subsequently, if the charge sheet is filed, that stage, charge sheet can be quashed. If there's no material on the charge sheet, which could lead to your conviction. Like, for instance, there are no witnesses. It's a lot of lacunas in the investigation. You know, no judge could reach a probable conclusion based on that charge sheet or the witnesses examined. High Court might do an assessment and quash that FIR charge sheet also. The third category would be when the magistrate or a special court has taken the cognizance of a matter. Taking cognizance of a matter means issuance of process. Cognizance taken, process issued, summons issued. That stage also, you can see, look, these summons are issued without an application of mind. Why there is no application of mind? Because the magistrate did not read the challan. He just mechanically issued the process, and the entire challan is absurd. You know, I don't want to face this trial. He should have read the challan and issued the process. Okay, the very fine distinction. If you file in the practical life, if you happen to file a private complaint, where you file a private complaint under section 190 CrPC, which then goes on to recording of evidence under section 200 CrPC. All right. And then if the after the preliminary evidence is done, magistrate would issue you process, the accused person. Or if they decide that I don't want to do a trial, they will dismiss your complaint under section 203 CrPC. So very interestingly, when a private party goes to a magisterial court, majority of the time, these complaints are dismissed, like right, left, and center. Even after adducing proper evidence, because that point in time, magistrate is actually applying their mind. They read, they hear to the evidence, they scrutinize the evidence, they listen to, read the testimony of the witnesses before they pass an order that this case should go on or it should not. However, when a challan is filed by the police, even if there is nothing in the challan, magistrates by default will issue process. They automatically come to conclusion that, okay, this case should go on trial. So this is what happens in the practical life. Should not be the case. Both the cases should be on equal parity. That's what my submission is. Okay, so these three cases can be categories. You can invoke 482 to quash either the simpliciter FIR or the challan or the issue of process or all three. So different high courts would ask you, for instance, if you go to Delhi High Court and you simply say, kindly quash the charge sheet and the process issued against me, they will admit the petition. But if you go to Punjab and Haryana High Court, they will say that it needs to be part of your prayer that FIR dated so-and-so should be quashed, challan dated so-and-so should be quashed, process dated so-and-so should be quashed. So you have to mention in your prayer all three, whatever you want to quash. It's just not that you say charge sheet should be quashed because FIR is part of the charge sheet. So it's once happened with me that we did not mention it in the prayer and we had to withdraw it and refile it with this specific prayer. So of course, FIR lodged beyond territorial jurisdiction. If it's a different territorial jurisdiction, you do not have any locus standi. The police does not have any jurisdiction to register the FIR. You can go to the High Court to quash the FIR. Petition to alter sentence. So there is a sentence. You can file a separate sentence seeking that, okay, in interest of justice, kindly alter the sentence. You're not challenging the appeal. You're not challenging the conviction. Simpliciter. All you're doing is you want the High Court on mercy basis to alter the sentence to a lower degree, passed by a trial court. So you might go in 482 saying, kindly alter the sentence, blah, blah, blah. He's guilty of this. And, there's a family to be taken care of, and whatever you want to say. Petition for cancellation of bail. So if there is a bail application and if the accused person is not complying with the complying. So can you give me some grounds when the bail can be cancelled? Who can give me grounds when a bail can be cancelled?
Hello?
Yes.
So when the explicit conditions of the bail are being violated.
All right. For example?
So for example, if the bail order says that XYZ person should report to ABC police station on Monday at 11 p.m. and he's not able to report without any valid explanation, then that could be a ground, sir.
Very good. Very good. So if the conditions mentioned in the bail are not being complied with, or for instance, you'll not tamper with the witness, you'll not go close to the witness, you'll not leave the country, you'll not do this, you'll not do that. If you become a defaulter, then the aggrieved party, the complainant or the state, knowing this, could move to High Court for cancellation of the bail. This is different from the cancellation of the bail, which is a misnomer, when you have absconded or you did not appear on your next date of hearing. Okay, if you have not appeared on the next date of the hearing, the magistrate is going to issue notice to your surety, come and discharge the surety, and issue a notice to you, a warrant, a bailable warrant, and so on and so forth. That's when you're going to come back and apply for recalling of the warrants, get a new surety, because once the surety is discharged, you have to file a new surety. All right, but that is not cancellation of bail. It's not that you have to argue the bail again. All you're doing is you're recalling the warrants, filing a new surety, and you're good to go. That is what is happening there. Yes, Mr. Chopra.
So this remedy wherein the person applies for the cancellation of bail for the accused, it lies only with the High Court, or it can be done with the Sessions Court also in case the conviction is done by the trial?
Technically, the remedy only lies with the High Court.
Okay, sir.
Yes. 1 second, I'll just bring my CrPC. Mr. Chopra, if you have CrPC, please read 446 alpha.
So where it says procedure when bond has been forfeited. Yes, sir. Where the bond under the code is for appearance or for production of property before a court, and it is proved to the satisfaction of the court or of any.
No, the 446 alpha, the next one.
Next, okay, 446A. Okay, sorry. Cancellation of bond and bail bond without prejudice to the provisions of section 446, where a bond under this code is for appearance of a person in a case and it is forfeited for breach of a condition. A, the bond executed by such person as well as the bond, if any, executed by one or more of his sureties, in that case shall stand cancelled. And thereafter, no such person shall be released only on his bail, on his own bond. In that case, if the police officer or the court, as the case may be, for that appearance before whom the bond was executed is satisfied that there was no sufficient cause for the failure of the person bound by the bond to comply with its condition, provided that subject to any other provisions of this code he may be released in that case upon the execution of a fresh personal bond for such sum of money and bond by one or more of such sureties as the police officer or the court, as the case may be thinks sufficient.
All right. So there is no express provision. If you read this chapter, provisions as to bail and bonds from 436 till 450, there is no express power which lies with the magistrate to cancel the bail. Okay. So CrPC does not give you any power. Now I'll give you a scenario. You have been enlarged on bail and you do not. Guys, I need to attend a call. Give me 5 seconds. All right. So there is no express provision which gives powers to magistrate to cancel the bail on an application. Okay. So what maximum a magistrate can do is, magistrate, if you've been declared a PO, like for instance, you absconded. The police, you've been absconded, you've been declared a proclaimed person or a proclaimed offender, there would be a subsequent FIR. All right. So once there is a subsequent FIR, the police is going to search you in that subsequent FIR. It's a suo motu FIR by the court. You will be arrested and you will be brought back to the court. Now, in order for you to get released from the court, you have to apply for the bail in that subsequent FIR. However, the initial case, your bail stays intact. All you have to do is you have to file a new surety and apologize to the court, recall of warrants, whatever it is. You know, my lawyer did not inform me, I was sitting home, blah, 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 whatever reasons are, you're going to tell. But the magistrate has no power to cancel your bail. So you will stay in the jail because you've been declared a PO or a PP in a subsequent FIR initiated by the court itself. But for instance, you need to cancel the bail on those grounds, which Akshay rightly mentioned. You have to go to High Court as an aggrieved party. That is what the difference is.
Right, sir.
Because a lot of people get confused in it, but they technically don't have power to do it. And a lot of lawyers, what they do is they start filing a subsequent bail. कि अच्छा तुम्हारी तो bail cancel हो गई है, हमें दोबारा बहस करनी पड़ेगी. जमान पैसे ले आओ, बहस करेंगे, bail कितने पैसे लगेंगे, जमानती कितने पैसे लगेंगे. The client won't know, but there is no real बहस. It's just that surety change कर दीजिए और bail पे discharge allow कर दीजिए. That's what the difference is. All right.
Sir, I have a question.
Yes, please.
Sir, can the same surety be furnished for, I mean, the same person, can he or she be the surety for the subsequent bail?
Absolutely.
Yes, sir.
Insofar as you have all the money in the world to keep going for keep donating for this person, you can be surety till your lifetime.
Okay. Okay, sir. Thank you.
All right. You just need to keep providing that 50,000 to the court every time he runs away.
Okay, sir. So, but just a follow-up, sir. Court cannot, use its powers to, for the aggrieved party to ask them to change their surety. Can the court do that? Or has the court ever done that?
Aggrieved party, I don't understand.
As in, for the subsequent bail, if I'm applying for a subsequent bail, can the court tell me to, no, I won't allow you to have this person as surety because he was your surety in the earlier bail?
No, this won't be the ground. This cannot be the ground for, okay, so you can be surety for one person in one case. You cannot be surety for multiple people.
Okay.
Yes, unless you can show that kind of assets. Look, yes, I can be surety for all 10 of my friends who were drunk last night in the court. Sorry, in the bar. They were, engaging in fights and fist fights and so on and so forth. I have these 10 lakhs. I'll deposit the FDR. Court will accept it. But if you do not have that kind of a bandwidth, and you know, all you have is 50,000 in the pocket and you want to file surety for multiple people, that is not going to happen. Yeah, so that is the difference. Number two, what is important here to notice, if the court is not satisfied with the bona fides that you are a good surety, you know, you could be a fake surety, they can refuse taking your surety. They can even refuse taking your surety if you're not a local. That happens in practice. Supreme Court has a different point of view, but that happens in a practice that we want a local surety. Not many people actually go to High Court and challenge that point, and they would end up arranging a local surety and moving ahead. So that's what happens in the practice. Moving on, cancellation of bail. Yes.
So in certain cases, I've observed, I was just going through certain judgments. There are lots of cases wherein people are not able to procure a surety.
Yes.
So I was just going through one of the judgments of Punjab and Haryana High Court, wherein they say in case a person is not able to procure a surety due to any reason, then CrPC 445 is what the advocate should go in for.
Correct.
So I was just going through that. I could not understand one line in case, can I be allowed to read that particular line? So
I think you need to read 443.
443, okay. Okay, may I?
Yes, please.
So, because I didn't see 443, I was going through 445 because I
correct provision is
judgment,
443.
yes. Okay, because that was mentioned in that particular judgment, so I was focusing on that one. So 443 says power to order sufficient bail when that first taken is insufficient. If through mistake, fraud, or otherwise insufficient sureties have been accepted. Because the judgment very clearly said 445 is the one wherein the most of these kind of.
Sorry, 440, man. We keep on applying. Just please go to 440 subsection 2.
440. The amount of bond and deduction thereof. This is the in subsection 2.
Yeah.
The High Court or code of section may direct that the bail required by a police officer or magistrate be reduced. So, sir, in this is saying the bail should be reduced. The bail required. It basically means the amount.
Yes.
So my question was wherein you don't have a surety. The person has the capability to pay or maybe submit that amount, but he doesn't have the surety to stand by him to give a bond. So in that particular thing, it was mentioned that section 445 is what is applicable. Deposit instead of recognizance. And there was a judgment also, but in this entire, it's a 5-line para, this section.
Correct.
I could not understand just one line in this. If you allow, I could.
Please.
When any person is required by any court or an officer to execute a bond with or without sureties, such court or officer may, except in the case of bond for good behavior, permit him to deposit a sum of money or government promissory note to such amount as the court or order officer may fix in lieu of executing such bond. Now, this bond, the last word, such bond means the bond. I could not understand. Such bond means, and there in the third line it says, except in the case of bond for good behavior. So when we talk about good behavior bond, does it mean that Kalandra bond that we are talking about?
Yeah. It's the executive magistrate bond under the chapter. That one is the good behavior bond. But if you are in, like, for instance, you've been arrested and you've been lodged on bail, you have nobody to take care of you, but you have money in your bank. All right. So you can tell the judge, look, I do not have anybody to stand surety. What I'm going to do is I'm going to go to the bank, get the money, deposit it in the court. So if I am not available next time, please forfeit that money. The scope of bail is only limited to forfeiture of that bond. right? If I've been enlarged on the bail, nobody else is going to get arrested. They're going
Such bond. Now, this bond, the last word, such bond means the bond. I could not understand. Such bond means, and there in the third line it says, except in the case of bond for good behavior. So when we talk about good behavior bond, does it mean that Kalandara bond that we are talking about?
Yeah, it's the executive magistrate bond under the chapter. That one is the good behavior bond. But if you are in, like, for instance, you've been arrested and you've been lodged on bail, you have nobody to take care of you, but you have money in your bank. All right. So you can tell the judge, look, I do not have anybody to stand surety. What I'm going to do is I'm going to go to the bank, get the money, deposit it in the court. So if I am not available next time, please forfeit that money. The scope of bail is only limited to forfeiture of that bond, right? If I've been enlarged on the bail, nobody else is going to get arrested. They're going to call Mr. Chopra and say, look, you stood surety for Shikhar. Kindly come and give us these 50,000 you stood for. आप अपने 50,000 देंगे और आप चले जाएंगे. ठीक है? That is all is going to happen. अब मेरे को next surety discharge करनी पड़ेगी, लानी पड़ेगी, या मेरे को दूसरा surety लानी पड़ेगी, and police, the judge is going to send me a notice, so on and so forth. That is going to happen. So as an alternative, I can also deposit money into the court, saying, look, I have nobody else to do this. I have money and I'm going to deposit this money. तो मैं गया तो any which ways आपको नोटिस भेज के मुझे दोबारा बुलाना पड़ेगा, और मैं तो दोबारा पैसे जमा करूंगा या कोई और श्योरिटी लेके आऊंगा.
So in this case, the advocate or the counsel has to file an application that since there is no surety available.
Not really, or verbally बोल के हो जाएगा. I mean, the accused or an advocate can say, look, if you don't want to release him, generally what happens is there is no surety. The judge would release you on a personal bail bond, depending on how heinous the crime is. ठीक है? अगर 498 3 years तक का है या कुछ भी है, तो आपको पर्सनल बेल बॉन्ड पे छोड़ देंगे बोल के कि कल ले आओ, अभी आपसे अरेंज नहीं हो रही है. तो आप भागोगे नहीं, आप जाके इसमें एप्लीकेशन लगा दोगे बोल के कि लोग I want to deposit this amount and this is what is happening. Otherwise, you can even simply tell the court and the court is going to act on it. That's not a big deal. But if it's a heinous crime, you've been enlarged on bail, there is an order from the High Court, that's when the court might send a police officer with you. कि अच्छा आपको बैंक जाना है, आपको ये जाना है, तो वही पुलिस ऑफिसर को भेज देंगे जो आपको आईओ अरेस्ट कर रखा है कि इसको बैंक लेके जाओ, इसको घर लेके जाओ, let him collect his checkbook, let him do all these formalities. Once this is all done, bring him back. समझ रहे हैं? ये डिफरेंस
Yes,
है.
sir. Yes.
अब अगर going further more in this area only, अगर आपका जो बेल बॉन्ड है वो आपके पास पैसे नहीं है देने के लिए, आपकी श्योरिटी कोई भी अरेंज नहीं हो रही है गरीब लोगों में, you could file an application in 440, please reduce my bail bond, I can't submit a bail bond for 50,000. So we have got these orders from the Sessions Court and High Court, जहाँ पे 50,000 की श्योरिटी 15,000 तक हो गई है, 10,000 तक हो गई है, and then we could get them released because it's easier for people to arrange this amount of money. तो अगर सेशंस कोर्ट इसको डिसमिस कर रहा है तो आप हाई कोर्ट में चले जाइए 482 में, तो कॉन्स्टिट्यूशनल कोर्ट विल अलाउ दिस. बट होता ये है कि जो गरीब आदमी होता है उसके पास अगर 15,000 रुपए श्योरिटी देने के लिए पैसे नहीं है तो हाई कोर्ट के वकील को अफोर्ड नहीं कर सकता है ना, उनकी आवाज वहां तक पहुंचती नहीं है, तो वो यहीं पे दबे रह जाते हैं. एंड अ ट्रायल कोर्ट लॉयर इज नॉट गोइंग टू पुल एनी स्ट्रिंग्स एंड अप्रोच हाई कोर्ट until unless you're in Delhi. So lot of bottlenecks are there for you to reach to the justice. Okay. Exercise the power to review or revise its own order. If there is an error in the High Court's own order, you will invoke 482 for the revision of that order. Look, there is a palpable mistake, or the order was passed ex parte. बहुत नुकसान हो जाएगा अगर ये order sustain कर गया, so on and so forth. Instead of going into SLP, you will file in 482 saying, please review your own order. It's a criminal order. All right. to release a prisoner. Can a magistrate or a sessions judge revise its own order in criminal case? Akshay?
No, sir, I don't think they can.
Okay. Can they revise their own order in civil cases?
I think so, sir. I'm not very sure, but I suppose there is a provision that they can amend their order. I'm not really sure. So I think, but criminal, yes, I don't think they can. In civil,
Okay.
probably maybe, but in criminal, I don't think so.
All right. Civil, they can. The provision is called review. Okay. And there is no provision of review in the CrPC.
Okay, sir. Okay.
There is the review. The scope of the review in CrPC is restricted to 381, which is no, not 381. 362 maybe. Uh, 362, court not to alter judgment. So 362, you can only alter your judgment if there is a numerical error on face of it or a factual error on face of it, but you're not going to alter the conclusion. ठीक है, आप कोई मेंटेनेंस ऑर्डर बना रहे थे,
Yes,
उसमें
sir.
आपने कैलकुलेशंस गलत कर दिए हैं या कोई फैक्चुअल इरेगुलरिटी हो गई है, so you can file an application saying please correct this factual error. The court will correct it. But for any such order passed, the only remedy you have is revision, appeal, or 482. However, a high court can alter its own order in CrPC in criminal courts cases. So in civil cases, of course. Okay. Power to release a prisoner on a parole. That can happen in 482. Parole generally, it's a power lies with the government. You give an application to the government. So, for instance, if you're a politically important prisoner, the government wants to favor you, so on and so forth, आपका parole बहुत आसान हो जाता है. But अगर government आपके favor में नहीं है, तो आपका parole बहुत मुश्किल हो जाता है. तो इस कंडीशन में आप क्या करेंगे? आप कॉन्स्टिट्यूशनल कोर्ट के पास जाएंगे कि भाई गवर्नमेंट डजंट लाइक मी, आई एम अ पॉलिटिकल प्रिजनर, आई गेव देम द रिप्रेजेंटेशन, दे रिजेक्टेड माय एप्लीकेशन, काइंडली डिसाइड माय पैरोल. सो इट इज काइंड ऑफ अ रिट. अब रिट में क्या करना होता है? इट्स एन ऑर्डर टू अ गवर्नमेंट. तो आप एक पहले representation दे चुके हैं, so you can't just simply go to High Court and say कि look, I be released on parole under Section 482. You have to first take steps of giving representation to the government. Please keep that in mind. Understood? To compound the offence. So compounding of the offence, there are certain offences which can be compounded by the magistrate court or the sessions court, as per the CrPC, but the certain offences which cannot be compounded by the trial courts, you go in 482 to compound the offence. Alternatively, you call it mutual quashing. When the parties have come to settlement, if you go to high courts, there is a separate list of mutual quashing. तो आपकी जब आपकी जब इनिशियल अर्जेंट लिस्ट खत्म हो जाती है, तो आपकी म्यूचुअल क्वॉशिंग की लिस्ट शुरू हो जाती है. वो इसलिए होता है क्योंकि दोनों पार्टीज कोर्ट में आई होती हैं, accused and complainant, plus there is a government because it's an FIR. So there are three parties who are interested in that FIR. One is state, one is the complainant, and third is the accused. So उन तीनों के counsels खड़े होते हैं. And then they say कि compromise has been achieved between the parties. My lord may quash the FIR. So it's technically compounding of the offence, and only those offences could be compounded which are heinous in nature, not extreme heinous, above than the ones which can be compounded by the magistrate or session court in 362 CrPC. Okay, there is a list of offence in CrPC which can be compounded by the trial court. Then anything beyond that, please open your CrPC and see this section. Yeah.
So is it 320?
Yeah, sorry, 320. I'm so bad with numbers. Yeah, 320, 196 page. Read करिए सर एक पहली line. So you see the offence punishable under the sections of IPC specified in first two columns of the table next may be compounded by the person mentioned in the third column of table. ठीक है? तो ये कंपाउंड कर सकता है वो, उसको मैजिस्ट्रेट कोर्ट में जाके बोलना है कि look, I want you to cancel this complaint and stop this trial. I'm settling down with the party. ठीक है? फिर उसके बाद जो second list है उसमें the offence punishable under this section of IPC, first two columns table next following may within the permission of the court before which any prosecution for such offences pending be compounded by the person mentioned in the third column. तो जिसको इसमें बताया हुआ है कि ये जिस कोर्ट के अंदर प्रोसिक्यूशन चल रहा है उस बंदे के स्टेटमेंट से कंपाउंड हो सकता है. It is like withdrawal of the complaint. So for instance, if you go and want to withdraw your domestic violence complaint, all you have to do is, you are the aggrieved lady. You just have to go to the court and give a statement. Look, I don't want to pursue this case anymore. I want to withdraw this complaint. So complaint withdraw ho jayegi. But you can't do this with a 498A. All right. For that purposes, you have to go. अब देखिए 494 जो है marrying again during the lifetime of a husband or a wife. 494 can be compounded. Can you see that? $312 can be compounded, causing miscarriage. Voluntary causing grievous hurt can be compounded. जिसको मार पड़ी है, grievous hurt हुआ है, वो बोलेगा जाके कोर्ट में कि इसको खत्म कर दीजिए तो खत्म हो जाएगा. उसको हाई कोर्ट जाने की जरूरत नहीं है. Okay, interestingly, 498A in Andhra can be compounded. I think all the states should do this amendment because it's wasting a lot of time in the High Court. Half of the compounding of quashing happens in the High Court are of matrimonial nature. ठीक है? So ये सब compound हो सकता है. तो जो नहीं compound हो सकता उसके लिए आप High Court जाएंगे 482 में आप एक quashing petition बनाते हैं जिसमें आप respondent लिखते हैं कि ऐसे ऐसे criminal machinery got into the motion based on the complaint of respondent number 2, so on and so forth. ये हुआ वो हुआ, I got arrested, this happened, that happened. Wide agreement between the parties, they have come to mutual compromise. They have filed for the first motion of divorce. Attaches the copy of the first motion of divorce, attaches the copy of the settlement agreement, so on and so forth. And prayer, kindly in interest of justice, the FIR challan process be quashed against the petitioners. ठीक है? ये प्रेयर होने के बाद अभी क्या है कि आपका अगर दूसरी पार्टी से अच्छी खासी बनती है तो दूसरी पार्टी के जो वकील साहब होंगे एडवांस नोटिस पे वो वहां खड़े होंगे. स्टेट तो होता ही है, तो दोनों पार्टीज नोटिस ले लेंगी. इफ इट्स पंजाब एंड हरियाणा हाई कोर्ट, इट इज गोइंग टू से कि प्लीज गो एंड रिकॉर्ड योर स्टेटमेंट्स इन द ट्रायल कोर्ट. Complainant has to go record her statement in the trial court. The trial court will send the status report on next date of hearing. If it is a Delhi High Court, वहां पे दोनों पार्टीज को बुला के रखते हैं. ठीक है? दोनों पार्टीज की स्टेटमेंट रिकॉर्ड हो जाती है और वो क्वॉश हो जाता है. ठीक है? दिल्ली में इट इज पॉसिबल. पंजाब एंड हरियाणा हाई कोर्ट में इट्स नॉट पॉसिबल बिकॉज पीपल आर कमिंग फ्रॉम different cities. कोई 6 घंटे से दूर आ रहा है, कोई 7 घंटे से दूर आ रहा है, तो they tell the high courts, trial courts to record the statement and come back on the next date of hearing. Status report आ जाती है. Parties can go to the trial court at their convenience. It's easy to enter. Maybe they're living in the same city, you know. It's much easier than traveling all the way to Chandigarh to do that. So this saves a lot of pain. That is also done in 482. Here, power to exercise against interlocutory order. Interlocutory order, I've given a lot of Gyan in the first lecture. Difference between interim order, interlocutory order, and final order. So interim order, of course, there is a substantive right. Interlocutory order are more procedural orders. So classic example is dismissal of CrPC 91. It's an interlocutory order. It could eventually decide your decision in your favor, or it could have not affected your outcome. So, but if you really think that, you know, this particular evidence needs to be on record, otherwise your case is going to be thrown out of window, whatever it is, in interest of justice, you invoke 482 and convince the court that, look, I really need this evidence. All right, that would be a classic example. तो आप 482 CrPC में जाएंगे. Prosecution based on illegal searches and seizures. तो अगर कोई illegal search हो रहा है और seizure हो रहा है, पुलिस ने कर दिया है illegal search and seizure आपके ऊपर, तो उसको भी आप खत्म करने के लिए 482 में जा सकते हैं. Any illegal activity which the police is doing, go in 482 in order to stop that. Okay, so these are exhaustive areas where you can, not exhaustive, I would say, practical areas where you could be invoking 482. I'll give you an example. Very recently, a client came. उसका ये case है कि he has this 3-story building which is entirely in his name, and ground floor पे he's got a shop. He lives with his family. उसका जो brother and sister-in-law है, they have a marital discord, who happens to be living on 2nd floor. This gentleman filed a suit for eviction. Execution के भी orders हो गए थे, but she somehow convinced the police to allow her to stay 1 or 2 days more. In the interregnum, she moved in the DV Act and took stay on the order, residence order के लिए, that she should not be dispossessed from the house. तो वो वहाँ पे बैठ गई. अब because there is a DV order, the police could not evict her. अब what she does all the time is she keeps, like, she goes to the shop downstairs, she would misbehave with people, she would misbehave with customers. उसने बाजू वाले घर जो पार्टीशन है 2 हाउसेस के बीच में जो किराएदारों का मकान है, उसमें भी उसने गैती लेके दीवार को में बहुत बड़ा दरवाजा बना दिया. Technically remove the wall all by herself. She would do all sort of stuff. अब problem ये है कि because of this woman and a nonsense of ulterior motive is to basically do kabza on this house. The husband has been thrown out already. He has parked himself in a rental accommodation at a distance. So she all by herself and with her kids is living in this house, and her ulterior motive is to drag this family also out of this house and do the kabza. अब क्या है कि we are going into 482 saying that she should be removed from this house for 2 reasons. First, I have the eviction decree in my favor. I have the execution decree in my favor, which she somehow delayed in this thing. और DV में भी ये लिखा है कि process of law follow करके आप इसको evict कर सकते हैं. But till then, she should stay here. It's a misconceived fact. We were following process of law. So अब क्या है कि it's an abuse of the process of law, technically speaking. She has no right to stay in that house. Now, having said that, I am losing a lot of money on daily basis because I can't keep any tenant in the house. 2 floors में मैं tenant रख ही नहीं पा रहा हूँ और मेरा काम business भी नहीं चल रहा है because she comes and misbehave with customers as and when she fancies. So we'll be filing a 482 to technically evict her out of this house in the interest of justice, and we'll say कि look, we'll provide her with an alternative accommodation which because she has a right to residence or whatever it is, but you please remove her from here. Because if this case stays in the trial court, इसको कोई बाहर नहीं निकाल पाएगा. So once you have the orders in the interest of justice, like okay, हमने इसको घर भी दे दिया, आप इसको बाहर निकालो, हमें कमाना है, हमें किराएदार नहीं रख पा रहे हैं, हम इसको मेंटेनेंस नहीं दे पा रहे हैं, तो हाई कोर्ट will be only the right person to look at in the holistic approach. But we can't do this with the trial court. If I go and argue in the trial court is going to say, look, maintenance issue is not my issue. Residence issue is not my issue. मैं तो सिर्फ सूट एग्जीक्यूशन ऑर्डर्स पास कर सकती हूँ. उसके बाद क्या होता है, मेरा कुछ लेना देना नहीं है. But the High Court is going to hear in toto सबकी राइट्स को मद्देनजर रखते हुए. You're not throwing out a victim of domestic violence. I mean, I'm just being sarcastic. If at all she's a prima facie victim of domestic violence, you're not throwing her out. Also, you're preserving the right of the landlord. Also, so on and so forth. So this is one place where you can use 482 adventurous area. ठीक है, अगर आप घास काटने वाली वकालत कर रहे हैं तो आप compromise quashings करेंगे. अगर आप थोड़ा सा adventurous जाएंगे तो there is lot of adventure in 482, which people do not know how to use. Yes, Mr. Chopra, I have a question.
So one more thing, I just like there was a case of Radhya's Bachchan today, which I was going through. Do normally celebrities go with under this section to somehow stop the videos from being viral on the internet? What is the section? Because they get relief in one day. So is this the section wherein they get the relief?
Ideally, that should not be the case, because she can always file an injunction suit and so on and so forth. तो अब होता है ना, अभी उसके साथ जो ये दिल्ली मिनिस्टर के साथ हुआ था, Kodhia के साथ, when they approached directly to Supreme Court, and Supreme Court said, please go to Magisterial Court. We can't be entertaining you just because you're a chief minister. समझ रहे हैं? अब होता क्या है? The first thing they do is, why this happens, the first thing they do is they would go to the best Supreme Court lawyer or a High Court lawyer in the city. ठीक है? अब they know she's an Aishwarya Rai, Sasodiya, जो भी है, उनको लॉ की इतनी नॉलेज नहीं है, उनको तो सेंसेशन चाहिए. अब the moment you approach a senior advocate बोलेगा हाँ मैं फाइल करता हूँ तुम्हारा केस हाई कोर्ट में, सुप्रीम कोर्ट में. Clearly they know it's going to be thrown out of the window. They will take money. They will file the case. Next day, तू कौन मैं कौन? समझ रहे? So they're not going to tell you, please go downstairs, use your effective remedy. A trial court lawyer is going to do it for 50,000 or 1 lakh. It's a simpliciter remedy. वहाँ पे तो अपनी 10 लाख रुपए की फीस नहीं जाने देंगे ना. ये होता है. तो रियल वकालत में आपके vested interest होते हैं, बहुत कुछ होता है. So that decides the kind of remedy you take, and if it's thrown out of the window or if it's admitted, a lot of things. Ideally, it should not be admitted.
This can go, a sort of a writ can go under 482. See, it was in today's paper that his daughter, granddaughter, there were some videos on YouTube wherein she was said she was not healthy, she has some mental issues. Those kind of videos are floating, news are floating on YouTube. So today itself, the High Court has directed the YouTube and the other channels to delist all those videos and remove all those videos from them. So I was just asking, is this the section that
I think this would be an appropriate remedy, because it'll be difficult for a civil court. It's an immediate remedy you're seeking.
For the child, yes.
Correct. So High Court might exercise its power, and High Court का order बहुत powerful होगा.
So this is the section basically which would
you can. I mean, you can give it a shot. I wouldn't say that there's no absolutely bar on using it. In interest of justice, you can. Yeah. Otherwise, आप civil court में injunction file करते, so on and so forth. That would have been taken a lot of time, and notice issue होता, ये होता, वो होता. यहाँ पे writ में क्या है कि 482 प्राइवेट पार्टीज पे भी हर किसी पे लागू होता है. रेट्स जो हैं वो सिर्फ गवर्नमेंट पे लागू होती हैं. तो इसका स्कोप बहुत ज्यादा बड़ा है कंपेयर टू 226 एंड 227. ठीक है, तो अब you can invoke it if it helps you. All right. अच्छा. One second, guys. I think I've opened a wrong folder. All right, here. Hello, Nandini. Long time no see. Can you see the screen, guys? Okay. All right. So this is the way. Have I discussed the Bhajanlal judgment with you guys? Okay, I'll very quickly discuss. Is the screen still being shared?
Yes, sir.
Okay, मैं आपसे एक बारी फैक्चुअल मैट्रिक्स बता देता हूँ, फिर मैं बताता हूँ कि कौशिक नहीं, मेरे को पहले वो बताना पड़ेगा कि अच्छा चलो ठीक है, ग्राउंड्स पे आएंगे तो बताता हूँ. Okay, criminal petition under section 482 of CrPC on behalf of the petitioner for quashing of impugned charge sheet arising out of FIR number so and so of Juvenile Justice Act 506 IPC dated so and so, sector so and all subsequent proceedings emanating thereof. Therefrom in CHI number this pending before the learned court of judicial magistrate first class blah blah blah. आप उसको repeat कर दोगे, फिर आप बोलोगे कि how did the criminal machinery or motion got set into the motion on the complaint of so and so person. So in this case, there was this child helpline Faridabad who was the complainant. Based on the the father used to beat the child and blah blah blah. उसको खबर मिली माँ से, फिर वो गए. Attaches the copy of the FIR. फिर investigation जब हुई तो investigation officer ने चालान file किया on so and so date, and petitioner was charge sheeted under so and so section. Annexure P2 is the copy of the chalan. The petitioner is the resident of blah blah blah. A brief facts leading to the present petition are as follows. क्यों आया हूँ मैं 482 में? That petitioner and one Samaira, respondent number 3. Okay, so why she's respondent number 3? Because she's the mother of the child who's been the real complainant. Child helpline is the ostensible complainant. तो पहले माँ ने child helpline को complaint करी, फिर child helpline सरकार की जैसे state complainant बनता है वैसे ही child helpline भी complainant बन गई. तो इस केस में 2 complainants बन गए सरकार की तरफ से. एक चाइल्ड हेल्पलाइन बन गई और एक स्टेट बन गया. मदर जो है वो रिस्पोंडेंट नंबर 3 है बिकॉज शी वाज द फर्स्ट इन्फॉर्मेंट. ऑलराइट, दैट देयर आर अब हम बोल रहे हैं कोर्ट को कि लुक देयर आर एन ऑनगोइंग मैट्रिमोनियल डिस्प्यूट्स बिटवीन द पिटिशनर एंड रिस्पोंडेंट नंबर 3 सिंस फरवरी 2017 एंड रिस्पोंडेंट नंबर 3 आर्बिट्रेरली वो डिसर्ट करके अपने घर आ गई. उसके बाद failed attempt to reconcile the relationship, multiple cases were filed between the parties. So अब इस केस में हुआ ये था कि this woman there's a matrimonial discord. There is a son aged 7 years who lives with the mother, and the father has a custody order for once every second Saturday in McDonald's for 2 hours. अब इस मदर ने क्या किया, उसने प्रण ले लिया, ऐसा बोलेंगे कि कुछ भी हो जाए मैं अपने बेटे को उसके फादर से बात नहीं करने दूंगी, वो वहां पे एक डमी की तरह बैठा रहेगा, वो 2 घंटे are going to be hell toxic, या मैं पुलिस भेजूंगी या मैं डिसरप्ट करूंगी उनकी मीटिंग, मैं सब कुछ करूंगी. I'll try my level best in order to sabotage this custody meeting for 2 hours. And that was her the only motive of her life. So she did that. So अब इस केस में हुआ ये था कि this woman there's a matrimonial discord. There is a son aged 7 years who lives with the mother, and the father has a custody order for once every second Saturday in McDonald's for 2 hours. अब इस मदर ने क्या किया, उसने प्रण ले लिया, ऐसा बोलेंगे कि कुछ भी हो जाए मैं अपने बेटे को उसके फादर से बात नहीं करने दूंगी, वो वहां पे एक डमी की तरह बैठा रहेगा, वो 2 घंटे are going to be hell toxic, या मैं पुलिस भेजूंगी या मैं डिसरप्ट करूंगी उनकी मीटिंग, मैं सब कुछ करूंगी. I'll try my level best in order to sabotage this custody meeting for 2 hours. And that was her the only motive of her life. So she did this for the year. हर visitation पे वो कुछ ना कुछ ऐसा ही करती थी. तो अब उसने क्या कुछ कुछ करके, कभी वो FIR रजिस्टर कराने जा रही है फादर के अगेंस्ट, फादर के दोस्त के अगेंस्ट की मेरा बेटे को किडनैप करने की कोशिश करी, कभी वो लॉयर के अगेंस्ट FIR रजिस्टर कराने की कोशिश कर रही है, कभी वो कुछ भी कर रही है, बट वो कर रही है, वो बैठ नहीं रही है आराम से, उसका ये एजेंडा है किसी तरह से. So the reason we need to give this entire factual matrix is in order to tell the court what is the background of this malicious prosecution. ठीक है, तो अब ये सारी कंप्लेंट्स हैं बिटवीन द पार्टीज की. डिवोर्स पिटिशन हस्बैंड ने फाइल किया, कस्टडी पिटिशन हस्बैंड ने फाइल किया, FIR नंबर 498 में वाइफ ने फाइल करी, ये मेंटेनेंस केस फाइल किया, FIR नंबर फाइल करी वाइफ ने, और IT एक्ट में भी वाइफ ने 3 FIRs फाइल कर रखी है मेरे अगेंस्ट. हस्बैंड ने एक FD के फ्रॉड में वाइफ के अगेंस्ट FIR फाइल कर रखी है, कस्टडी पिटिशन फाइल कर रखा है, डिवोर्स पिटिशन फाइल कर रहा है. दिस इज एन ऑनगोइंग लिटिगेशन बिटवीन द पार्टीज. ठीक है, वील मेंशन गिव द बैकग्राउंड ऑफ एन ऑनगोइंग लिटिगेशन. अब फिर हम चाइल्ड कस्टडी के ऑर्डर के बारे में बात करेंगे कि चाइल्ड कस्टडी का ऑर्डर हो गया, 11 बजे आपने देना है बच्चे को और 1 बजे आपने ले लेना है. अटैच इज द ऑर्डर. अब क्या है कि पिटिशनर जो है वो माइनर से मिलने गया 1 तारीख को 9/10/2021 को, एंड वाज इंट्रोड्यूसिंग द माइनर टू हिम टू हिज वन ऑफ हिज फ्रेंड्स. तो उस तारीख पे जब माइनर को वो अपने फ्रेंड से इंट्रोड्यूस कर रहा था, तो जो मदर बाहर खड़ी हुई थी वो पूरा ट्राइपॉड वगैरह लगा के कंटिन्यूसली रिकॉर्डिंग कर रही थी. शी केम इनसाइड मैकडॉनल्ड्स एंड हिस्टेरिकली अटैक्ड, मिसबिहेव विद द फ्रेंड. तो मेरे बेटे को किडनैप कर रहे हो, तुमने मेरे बेटे से बात कर ली, ये वो बहुत ड्रामा किया. वो इंसान भाग गया वहां से कि पता नहीं क्या हो गया. सो दिस वाज वन एपिसोड. नेक्स्ट एपिसोड पे क्या होता है, अब what she did is after this episode she went and filed a complaint in the police station saying कि look, there was this man accompanying my husband, he tried to kidnap my child, kindly write the FIR against him. अब पुलिस एक कंप्लेंट लिख के उसको वापस भेज देती है. ठीक है, सेकेंड डेट पे क्या होता है, वो एक और कस्टडी में एक और कोर्ट से ऑर्डर हुए होते हैं, एंड ही हैपेंस टू मीट द फादर ऑफ another child who is also present there. तो अब ये दोनों फादर्स आपस में बात करने लग रहे हैं, and you know they exchange pleasantries and the other father tries to speak to his child. Then also mother came rushing inside and he says, how dare you talk to my child, and ये वो सब ड्रामा करके वो इसके अगेंस्ट भी कंप्लेंट फाइल करने पहुंच जाती है। अच्छा, उस कंप्लेंट का भी एनेक्स्चर हमने लगा दिया। फिर क्या होता है कि अब क्या है, बेस्ड ऑन दीज टू इंसिडेंट्स शी मूव्स टू फैमिली कोर्ट सेइंग कि लुक, दिस कस्टडी ऑर्डर शुड बी मॉडिफाइड। अभी तक समझ में आ रही है सारी बात? This custody order should be modified because there are 2 occasions where my husband has tried to kidnap the child. ये 2 घंटे की कस्टडी उसको नहीं मिलनी चाहिए। अब family court knows very well what she's trying to do. Family court just sits over that order. So in the excitement, this woman now goes to Punjab and Haryana High Court, 227 writ, saying that family court is not passing an order in my application. There's a hell lot of urgency. My child is not safe. आप फैमिली कोर्ट को डायरेक्ट करो ऑर्डर पास करने के लिए। अब क्या होता है कि जब ये रिट का ऑर्डर आता है, हाई कोर्ट बोलता है फैमिली कोर्ट को कि अच्छा भाई आप ऑर्डर पास कर दो नेक्स्ट डेट ऑफ हियरिंग पे, तो फैमिली कोर्ट ऑर्डर पास करता है, वो क्या बोलते हैं, एडवर्स ऑर्डर पास कर देता है अगेंस्ट द वाइफ ओनली। फैमिली कोर्ट सेज कि हम कोई मॉडिफाई नहीं कर रहे हैं इस विजिटेशन राइट्स को, इट्स जस्ट 2 hours in a month, and you, the petitioner wife, is directed to remove yourself from McDonald's and park yourself outside for these 2 hours. तो फैमिली कोर्ट ही उसको बोल देता है कि अब तुम खड़ी नहीं होगी, ये वीडियो रिकॉर्डिंग सब बंद होगी। अब agreed with this family court order, what she does is she bribes the police and she starts sending police to monitor the custody for next 2 months. So we mentioned that, okay, what she did, she क्योंकि she was restrained from entering the McDonald's premises, she started sending 2 police officers. अब police officers को private party without an FIR and express order from the court cannot instruct जब तक आपने उनको पैसे ना खिलाए हो। ठीक है, आप उनको इंस्ट्रक्ट नहीं कर सकते हो कि जाके मेरी बेटे की चौकीदारी करो, ना तो फैमिली कोर्ट से ऑर्डर है ना मैजिस्ट्रेट से ऑर्डर है। ऐसे ऑर्डर्स तभी हो सकते हैं जब पुलिस के साथ आपकी बहुत ज्यादा दोस्ती है। करेक्ट। तो अब ये एविडेंस भी हमारे पास आ जाता है कि पुलिस को भेज रही है, मॉनिटर करा रही है, सब करा रही है। उसके बाद बात आगे बढ़ती है, यू मेंशन ऑल दिस, देन सब्सिक्वेंटली व्हाट हैपेंस इज कि अब because now 6-7 months have passed and she's not able to get a favorable order and she has to bring the child every month to McDonald's, she plans a conspiracy. वो बेटे को बोलती है कि misbehave with the father, and the father tries to lift the child to take him to a different table. अब वो बहुत ज्यादा हाथ पैर इधर उधर मारता है, बहुत ड्रामा करता है, और घर आके डिसाइड करते हैं, ये पुलिस को बोलते हैं कि मार पिटाई करी है उसने मेरे साथ, मेरे बेटे के साथ, तुम इसकी सीसीटीवी फुटेज लेके आओ। तो what police does is they go to McDonald's, they bring the CCTV footage without an FIR. They start investigating the matter. कोई FIR नहीं रजिस्टर हुई, कुछ नहीं हुई, तो CCTV फुटेज निकलवा लेती है लीगली, क्योंकि पुलिस को खरीद रखा है। अब then she prefers again one modification application in the family court saying कि look, he's been beating the child in those 2 hours, kindly modify this order and take the visitation rights back. अब notice issue होता है, और the council appears for the father and the council says, how in the world did she get the CCTV footage from police when there is no FIR? अब then they get panic. उसके बाद क्या होता है कि इस पर्टिकुलर डेट के बाद 1 जून को FIR रजिस्टर हो जाती है जुवेनाइल जस्टिस एक्ट में, सेक्शन 75 ऑफ जुवेनाइल जस्टिस एक्ट 506 IPC. So it's an afterthought, clearly. डेट ऑफ अकरेंस इज 14 में, 1 जून को आपकी FIR रजिस्टर हो जा रही। अब ये किसी को नहीं पता कि FIR रजिस्टर हुई है। FIR भी रजिस्टर हो गई, और नेक्स्ट डेट ऑफ हियरिंग फैमिली कोर्ट में पड़ती है आफ्टर वेकेशन, 4th July. अब this 4th July, when the petitioner father comes to the family court, what happens, उस दिन कुछ आर्ग्यूमेंट्स होने हैं, वो हो नहीं पाए, and this gentleman happens to go to the parking area of the court. 4 policemen and civilians, they come and they arrest him. वो ले जाते हैं उसको पुलिस स्टेशन। arrest करके on an FIR under section 75 and 506 of IPC. अब both these offences are not punishable more than 3 years. ठीक है? उसी दिन बड़ी मुश्किल से वो लेके आते हैं उसको मैजिस्ट्रेट कोर्ट में और सब कुछ होता है, बेल आर्ग्यू होती है, जज इनलार्जेस हिम ऑन बेल. आयो की स्टेटमेंट ली जाती है कि क्या तूने 41A का नोटिस इशू किया था? आयो बोलता नहीं, मैंने इनको फोन करने की कोशिश करी, इन्होंने फोन नहीं उठाया, ये बोलते रहे कि मैं नहीं आऊंगा, मैं आऊंगा, ये है वो है, ब्ला ब्ला ब्ला, ऑल द ज्ञान ही केप्ट ऑन गिविंग. अब आयो ने 41A का नोटिस इशू नहीं किया था. He had no evidence to that effect. So he gave the statement कि I did not issue the 41A notice. So the sole ground for him to get the bail was there was no 41A notice issued. इसके ऊपर एक और judgment भी है सतिंदर अंतल की, जिसमें the Supreme Court has categorized the cases and based on what kind of category you come across और आपको bail उसमें मिलेगी या नहीं मिलेगी करके. तो any offense Anesh Kumar, of course, is the basis of any offence less than 7 years. इस केस में notice नहीं issue हुआ, offence was punishable only up till 3 years, and police arrested him without any notice. They detained him. अभी क्या हुआ कि इसको bail मिल जाती है, plus the magistrate passed strictures against the police. He also orders the commissioner to take disciplinary action against the police, just based on the procedure they adopted. अब क्या हुआ? इसके बाद bail मिल जाती है, order भी modify नहीं होता है. ठीक है? The wife is extremely paranoid. She lost it now, finally. So again, arguments होते हैं इसी point पे कि how she got the man arrested in order to, you know, settle her scores and blah 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 blah. They thought कि FIR की वजह से इनको बहुत फायदा मिलेगा और उसकी visitation rights revoke हो जाएंगे. The judge was smart. Family court judge gave an order कि look, this मैंने वीडियो देखा, इसमें मेरे को कोई FIR, मेरे को कोई मार पिटाई नहीं मिली है. It's only the father is trying to lift the child and child is repulsive and blah blah blah, and this is the reaction what any father would have. This is the remark what the family court judge gave. So in what has happened now, they've been acting in lot of desperation. उन्होंने अपने against 2 orders बनवा लिए. एक तो family court से order बनवा लिया बोल के कि मैंने तो evidence भी सारा scrutinize कर लिया है, मुझे तो इसमें कुछ नहीं मिला. And this is a very natural reaction of a father. दूसरा, जब bail मिली हमको तो उसमें भी magistrate ने strictures pass कर दिया police के against. So these 2 orders are going to immensely help us in quashing this FIR. Now what happens is we take 2 remedies. We first file the contempt of Supreme Court as per the Anesh Kumar in Punjab and Haryana High Court against the investigating officer, SHO and ACP कि आपने अरेस्ट कर कैसे लिया 41A का नोटिस दिए बिना. ठीक है? Second remedy we took is we filed this quashing petition based on the 2 orders we received from 2 trial courts with their observations. तो अभी हमने उनको सारी कहानी लिख दी कि देखिए ये हुआ, उसके बाद फैमिली कोर्ट में आर्ग्यूमेंट्स हुए एंड फैमिली कोर्ट ने हमको ये ऑर्डर दे दिया, बेल हो गई हमारी, बेल ने हमें ये ऑर्डर दे दिया, ब्ला ब्ला ब्ला. ये राइटिंग है. बिफोर पार्टिंग, it is pertinent to mention here that the investigating officer of the present case has arrested the accused in total violation of the guidelines issued by Honorable Apex Court and Anesh Kumar. It is also not out of context to mention that the checklist in the present case has been filed by the investigating officer just to complete a formality. Accordingly, requisite information be sent to the Commissioner of Police Faridabad for initiating inquiry into the matter and thereafter to take appropriate action against the investigating officer. Further, it is suggested that Commissioner of Police Faridabad shall devise a strategy in order to sensitize the IOs of district regarding the compliance of the guideline issued by Honorable Apex Court and Anesh Kumar. So these were the remarks by the magistrate in the bail order. Look, it's a mala fidely instituted case. Second argument is ये family court का order है. During the course of arguments, the learned counsel for applicant respondent mother showed some screenshots of the alleged video footage of that day. However, from the said screenshot, it was apparent that the child was not willing to sit with his father, and the father was trying to take him in his arms, which is a natural reaction of any father who meets his child only for 2 hours in a month. The child continuously remains in the custody of his mother, the present applicant, for the whole of the month. The applicant respondent has failed to make out any special circumstances which may warrant the recalling or extensive modifying of order dated 14/9/2021. So these were the remarks from the family court. Both these remarks hurt their case badly. ये orders लेके हम हाई कोर्ट पहुंच गए. अब ये सारे orders हमने sequentially लगा दिए कि पूरी टाइमलाइन हमने बना दी कि कैसे कस्टडी ऑर्डर आया था सबसे पहले, फिर उसने फलाने स्टेशन में एफआईआर दी अगेंस्ट द फर्स्ट फ्रेंड. सेकंड डेट पे उसने फिर कंप्लेंट दी अगेंस्ट द सेकंड पर्सन हु द फादर मीट्स इन द मैकडॉनल्ड्स, हु हैपेंस टू बी मीटिंग हिज डॉटर इन द सेम प्रोमाइसेस. थर्ड डेट पे उसने फैमिली कोर्ट में मॉडिफिकेशन एप्लीकेशन डाल दी, फिर वो 227 में चली गई, फिर वो ऑर्डर मॉडिफाई नहीं हुआ, फिर वो पुलिस भेज रही है 2 डेट्स पे, फिर वो उसने सीसीटीवी फुटेज निकलवा ली विदाउट एन एफआईआर. Then she again filed a modification order. At this stage, there was no FIR, and when the council mentioned that there is no FIR, the police happened to register the FIR on 1st June. Subsequently, the police arrest him after a month's time without issuing 41A notice. Despite all this, custody order stays intact. The accused is enlarged on bail. अब हमारे पास 2 जुडिशियल माइंड्स अप्लाई हो चुके हैं, है ना. फैमिली कोर्ट हैज एक्चुअली स्क्रूटिनाइज्ड द मटेरियल. उसने कोई मारपीट नहीं देखी है, समझ रहे हो. तो प्राइमा फेसाई देयर इज अ जुडिशियल वर्डिक्ट कि भाई इसमें कुछ है ही नहीं, कोई मारपीट नहीं है. ये सारी कहानी लिख के फैक्चुअल मैट्रिक्स हम बता के अब हम ग्राउंड्स पे आएंगे. हमें केस बिल्डअप करना पड़ता है शुरू से एंड तक. अगर हम बिल्डअप नहीं करेंगे केस तो हम अब्यूज ऑफ प्रोसेस ऑफ लॉ नहीं बता पाएंगे. तो व्हाट इज वाइफ ट्राइंग टू डू इज क्लियरली अब्यूजिंग द प्रोसेस ऑफ लॉ. उसने ठान लिए कि मैं अपने इस बेटे को मिलने नहीं दूंगी इसके बाप से, और मैं किसी भी एक्सटेंट तक जा सकती हूँ. पुलिस को खरीद के, पैसा है मेरे पास, I'll file frivolous applications, I'll go to high court, I'll go to this court, I'll go to that. I'm not going to sit idle, है ना. But ultimately all this hurt her badly, all this desperation. अब अगर हस्बैंड के पास इंटेलिजेंट वकील नहीं होता तो हस्बैंड तो रो चुका होता अब तक, समझ रहे हो. तो अगर दोनों साइड्स पावरफुल नहीं है तो एक साइड बेसिकली क्रैशेस. अच्छा, अब ये सब लिखने के बाद गाइस, इज इट क्लियर टिल नाउ? नंदिनी, वाज इट क्लियर टू यू? Okay, so you need to build up your factual matrix in order to tell the court how the abuse of process of law has occurred. फिर आप grounds पे आ जाते हैं. One second, guys. Okay. Am I audible?
Yes, sir.
Okay. Akshay, can you quickly repeat the story? What has happened? Any of the 5 points?
Yes, sir. So basically, the case, the whole crux of the matter is we are representing the man who was initially allowed a custody visit as per the family court order, but the mother, his wife, bearing a vendetta against him, she did certain acts to sabotage the visit. The first act was to bribe the policeman and procure the CCTV footage without a warrant FIR. Second was to file a statement in the family court saying that using that CCTV footage as evidence to show that he's been abusive towards the child. And later on, when the family court denied the motion for amending the visitation rights, she then bribes the policeman and has him arrested without the proper procedure, as in 41A issuance of notice. And before that, she also, before the CCTV application, she also files a complaint against the husband under JJ Act with the child helpline. So now you're moving an application under 482 CrPC to seek quashing of the FIR, the initial FIR, which is filed by the Child Protection Authority, and showcasing the abuse of process and the abuse of law, which is being carried out by the wife and mother.
Very good. Thank you. Okay.
I'm sorry if I may have missed a couple of points, sir.
That's fine. I mean, insofar you remember this much, it's enough that you were listening. Yeah, it's just to. All right. So guys, before I move to the grounds, this is the very important part of the entire exercise. If you want to learn how to draft quashing, I do have SCC of this judgment, but I have to locate it in my folder somewhere. Okay, this is Bhajan Lal. This is a celebrated judgment of Bhajan Lal. The title is State of Haryana and Others versus Chaudhary Bhajan Lal and Others from 21 November 1990. Okay, this is the first time. Okay, there's one more judgment wherein Supreme Court has given certain guidelines in which conditions the cases can be quashed and cannot be. So here are express guidelines. So if you understand these guidelines, how they are used and how you have to use them, it'll become very easy for you to draft a 482 petition. Once you have got your factual matrix right, आपको उस factual matrix में से ये उठाना है कि अब आपके legal points क्या-क्या fit हो रहे हैं. अब आपको इस case में factual matrix. Do you see the judgment, guys, on the screen?
No, sir. No. Only grounds are visible.
Okay. 1 second.
Sir, meanwhile, can I ask a question? It's related to your case. Sir, you repeatedly say that any arrest which is done under Section 41A is a contempt of Supreme Court.
Correct.
And in this case, you're approaching the Punjab and Haryana High Court, citing the contempt of Supreme Court judgment. So is it possible, sir? Is it possible for any guideline which Supreme Court issues under Article 142?
Okay, this is one judgment and one more where Supreme Court has expressly mentioned that contempt of these guidelines, the parties aggrieved will be at liberty to invoke the contempt petition High Court of their jurisdiction. So if it is expressly mentioned, because it's not possible for everyone to go to Supreme Court, correct?
Yes, sir. Yes, sir.
और ये तो बहुत ज्यादा होने वाला था. तो अगर कोई उसकी कंटेम्प्ट की एक्सप्रेस वो नहीं एक्सप्रेसली सुप्रीम कोर्ट जजमेंट में नहीं लिख के दे रहा है कि भाई तुम हाई कोर्ट में इन्वोक कर सकते हो, तब तक तुम सुप्रीम कोर्ट ही जाओगे. उसकी भी जजमेंट है. बट इस पर्टिकुलर अनेश कुमार में उन्होंने just go through Anesh Kumar eventually, and you'll find out a point that any violation of these guidelines, the party agree are at the liberty to approach High Court of their jurisdiction. Yeah, so it happens in Anesh Kumar left, right, and center. आपको all across India Anesh Kumar की contempt की judgments मिलेंगे जिसमें पुलिस को उन्होंने जेल में भेजा है. इलाहाबाद हाई कोर्ट है.
Yes, sir. केरला हाई कोर्ट
केरला हाई कोर्ट है. पंजाब एंड हरियाणा हाई कोर्ट है. पंजाब एंड हरियाणा हाई कोर्ट में तो हमारी खुद की जजमेंट है. We were the first ones to get a judgment from Punjab and Haryana High Court. There were attempts initially to do it, but it did not turn out to be fruitful. So Delhi High Court की हैं couple of them. you'll find a lot of judgments. Okay?
Can I just ask a follow-up, sir? A quick follow-up. Sir, I am assisting a counsel who is fighting a matrimonial case, and then the parties were asked to submit the affidavits in the Neha Rajneesh format, the SCC, the Supreme Court guidelines under Article 142. So the other party has lied on the affidavit, and now, I mean, this is a question for my knowledge that can a contempt of Supreme Court petition be filed in the jurisdictional high court, or we have to go to the Supreme Court?
You will not file the contempt of Supreme Court in this case. You can file the contempt of Supreme Court against the magistrate or the family court if they have not taken the requisite affidavits on record and decided the maintenance. Under Article 142, huh?
ये हाई कोर्ट ने बोला था एफिडेविट देने के लिए, एक्चुअली रिवीजन पिटिशन था, तो वो जजमेंट जो है रिवीजन मतलब फाइनल मेंटेनेंस का वो नेहा वर्सेस रजनीश के जजमेंट के पहले, एंड द हाई कोर्ट देन यूजिंग द नेहा वर्सेस रजनीश जजमेंट they asked both the parties to furnish the affidavit. So the other party has lied on the affidavit.
Do you have the judgment of this point that High Court एक बारी order pass होने के बाद High Court ने बोला कि रजनीश वर्सेस नेहा को फाइल करके मेंटेनेंस?
Yes sir. The judgment is of January 2020.
मेरे को प्लीज आप ग्रुप पे हो ना, मेरे को शेयर कर देना. I want this judgment.
Okay sir. Okay. I'll then personally get in touch with you.
Please.
Okay. Thanks.
Which year are you and where are you based out?
Sir, I am an advocate. I am not practicing as much per se, but I'm planning to venture into practice. So I was working.
Are you based out of Ghaziabad?
No sir. I'm based out of Nagpur, Maharashtra.
Oh, you are in. Okay. Sorry.
Yes.
All right. Please share this judgment with me. Okay. Now, इसमें contempt के I'm a little tight on the time, but I'll quickly tell you. अगर magistrate और family court नहीं order लेके pass करता है, after the guidelines of Supreme Court have been released, wide effective 20th or 4th of November 2022. This judgment came on 4th of November 2022. उसके बाद के कोई भी order में अगर judge ने बिना affidavit लिए order pass कर दी है, so the contempt lies against the judge.
Okay, sir.
In Supreme Court.
Okay.
Now, if you have lied on the oath, then the remedy is 340 CrPC.
Okay, sir.
You have to initiate 340 CrPC because now the complainant becomes the magistrate जिसके कोर्ट में उन्होंने झूठ बोला है.
Yes.
समझ गए?
Yes.
तो मैजिस्ट्रेट को सैंक्शन देना पड़ेगा, उसको आपको कन्विंस करना पड़ेगा कि देखो इन्होंने इतना झूठ बोला एफिडेविट में, आप इसके अगेंस्ट क्रिमिनल प्रोसीडिंग्स इनिशिएट करो. That's your answer in short.
Yes. Thank you, sir.
Okay, no problem. Okay, now if you can see the screen, you can, Nandini? All right. ये 8 guidelines हैं. In the exercise ये आपको पढ़नी है और आपके इसी के ambit के अंदर आपकी वो बनेगी 482 बनेगी. Akshay, can you please do the needful? Can you read these guidelines? I'm a little tired. A से शुरू करो. ये 8.1 से शुरू कर दो. धीरे-धीरे पढ़ना. Akshay, can you hear me?
Hello. Sorry. Hello.
Yes. You're audible. Please start
sorry,
from 8.1.
I was muted. Yeah, sorry. I was muted. State of Bihar and others versus JSC Saldana and others, 1980, Volume 1, SCC, page 554. In the exercise of extraordinary power under Article 226 or the inherent powers under Section 482 of the Code of Criminal Procedure, the following categories of cases are given by the administration wherein such power could be exercised either to prevent abuse of process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guide Sir, I don't get that
Okay,
word.
just myriad
This
kind
is
of
myriad.
cases.
Yeah, myriad kinds of cases wherein such power should be exercised. Point A, where allegations made in the first information report or complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused.
अच्छा रुक जाओ एक second.
Ji.
So guys, the first point is the first ground. You need to scrutinize your FIR and see कि वो prima facie read करने पे क्या कोई cognizable offense या कोई भी offense बन रहा है, कोई case बन रहा है read करने पे, है ना? तो prima facie establish करना पड़ेगा कि मतलब उसने मुझे हाथ लगाया या उसने मुझे गंदी नजर से देखा या ये उसने मुझे गंदी नजर से देखा. Does that fall into the category of outraging modesty of a woman? अब हो सकता है कि हर लड़का हर लड़की को सड़क पे गंदी नजर से देखता है, तो क्या हर किसी पे आप 354 इन्वोक करते रह जाओगे? It's a very subjective thing. Till the time he actually approached you and he touched you inappropriately and so on and so forth. You understood? अब इसी एलिगेशन के बेसिस पे अगर 354 पुलिस इन्वोक कर देती है और एक्यूज को उठा के ले आती है, इट्स क्लियरली एन अब्यूज ऑफ प्रोसेस ऑफ लॉ. समझ रहे हैं? तो आपको ये देखना है कि प्राइमा फेसाई केस बन रहा है कि नहीं बन रहा, या छोटी सी बात का आपने राई का पहाड़ बना लिया करके. Because if the girl is pretty and she thinks that every man on the street is looking at her with a gandi nazar, that's not a ground for how do you say that? Registering an FIR against me. Okay. Point B.
Point B, where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense, justifying an investigation by police officers under Section 151, subsection 1 of the code, or except under an order of magistrate within the purview of Section 155.
He actually approached you and he touched you inappropriately and so on and so forth. You understood? अब इसी एलिगेशन के बेसिस पे अगर 354 पुलिस इन्वोक कर देती है और एक्यूज को उठा के ले आती है, इट्स क्लियरली एन अब्यूज ऑफ प्रोसेस ऑफ लॉ. समझ रहे हैं? तो आपको ये देखना है कि प्राइमा फेसाई केस बन रहा है कि नहीं बन रहा, या छोटी सी बात का आपने राई का पहाड़ बना लिया करके. Because if the girl is pretty and she thinks that every man on the street is looking at her with a gandi nazar, that's not a ground for how do you say that? Registering an FIR against me. Okay. Point B.
Point B, where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense, justifying an investigation by police officers under Section 151, subsection 1 of the code, or except under an order of magistrate within the purview of Section 155, subsection 2 of the code.
Okay. तो आपका जो फर्स्ट इंफॉर्मेशन रिपोर्ट है उसमें आपको सबसे पहले देखना है कि कॉग्निजेबल ऑफेंस बन भी रहा है या नहीं बन रहा. अगर 300 आपने आपके एक्यूज कंप्लेनेंट ने कंप्लेन करी है कि मैं गया मार्केट, मेरे को मिला अक्षय ने मेरे को 2 झापड़ जड़ दिए. आप इसकी FIR लिखो 323 में. क्या पुलिस लिख सकती है FIR?
No, sir.
नहीं लिख सकती है, बिकॉज इट्स नॉट अ कॉग्निजेबल ऑफेंस. झापड़ जड़ दिए इज नॉट अ कॉग्निजेबल ऑफेंस. वो ज्यादा से ज्यादा NCR काट सकते हैं. ठीक है? तो अगर आपके एलिगेशंस ही नहीं है कॉग्निजेबल ऑफेंस के और पुलिस फिर भी FIR लिख दे रही है, तो ये क्वॉश हो जाएगी. So this is the second ground. आगे बढ़ो.
Yes, sir. C, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in the support of the same do not disclose the commission of any offense and make.
Your voice is gone. And make out a case against the accused.
Yeah, and make out the case against the accused. Am I audible?
हाँ. तो अनकॉन्ट्रोवर्टेड एलिगेशंस का मतलब होता है कि जिसको आप रिबट नहीं कर रहे हो, जिसको आप चैलेंज नहीं कर रहे हो, दे वेंट अनकॉन्ट्रोवर्टेड मींस एक्सेप्टेड. तो अनकॉन्ट्रोवर्टेड एलिगेशंस मेड इन द FIR or complaint and the evidence collected in the support of the same do not disclose the commission of any offense. मतलब कि आप अगर उसको चैलेंज नहीं कर रहे हो तो उसी सिचुएशन में भी कोई ऑफेंस ही नहीं बन रहा है अगेंस्ट द एक्यूज्ड, एविडेंस के बावजूद भी. अब जैसे हमारे जेजे एक्ट के केस में हुआ कि एविडेंस कलेक्ट किया और एविडेंस palpably there is no single second where the father has slapped the child. That means इसको मुझे इसके अगेंस्ट में मेरे को कुछ देने की भी जरूरत नहीं है. The judge if applies his mind can see, look, there is no मारपिटाई. समझ रहे हैं? This is the evidence on the record and there is no मारपिटाई. So this case, this challan should be quashed. That's what it means. आगे बढ़ो.
D, where the allegations in the FIR do not constitute a cognizable offense, but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of magistrate as contemplated under section 155, subsection 2 of the code.
So it's a self-explanatory, non-cognizable offense में आप FIR लिख नहीं सकते हो. अगर पुलिस ने पैसे खा के लिख दी है, वो इन्वेस्टिगेशन करने चली गई है, तो आप इसकी क्वॉशिंग कर दोगे. आगे बढ़ो.
E, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused.
तो पूरी की पूरी FIR, allegations in the FIR are so absurd और improbable कि आप उसको पढ़ोगे, सुनोगे, आप विश्वास नहीं कर सकते हो. ठीक है? Maybe a classic example would be कि कुछ भी मेरे को मेरे ससुर ने नशीली दवाई दी और मैं बेहोश हो गई. ठीक है, फिर मेरा रेप हो गया, फिर मैं सुबह उठी, फिर मैंने अपने हस्बैंड को बताया, फिर मेरे हस्बैंड ने मुझे जान से मारने की धमकी दी कि अगर ये तूने बात किसी को बताई तो मैं तेरे को जान से मार दूंगा. तो if you just listen to the story, it sounds extremely improbable. तेरे को तेरे मतलब अगर इतना कुछ हो गया रात भर में तो तेरे ऑब्वियसली तेरे हस्बैंड को ये बात पता होगी, है ना? नशीली दवाई दी और तू बेहोश हो गई. And how do you know that your father-in-law raped you? Lot of things. So I mean, might not be a perfect example, but you get a gist of it, that how do you convince a court like the sequence of events is not probable. It is nonsense. That's what you need to tell the court. आगे बढ़िए.
F, where there is an express legal bar engrafted in any provision of the code or concerned act under which a criminal proceeding is instituted, to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the concerned act providing an efficacious redress for the grievance of the aggrieved party.
Okay.
Efficacious, sorry.
No problem. इसका example है bar of 195 and 197 CrPC. आप उसको read करिएगा. So you cannot register a complaint against the government officials directly. ठीक है? तो अगर आप एज अ प्राइवेट पार्टी किसी पुलिस वाले के अगेंस्ट FIR कराने जा रहे हैं, जज के अगेंस्ट कराने जा रहे हैं, सरकारी आदमी के अगेंस्ट कराने जा रहे हैं, तो वो अलाउड नहीं है. इट्स बार्ड बाय सैंक्शंस अंडर 195 and 197 CrPC. इट्स अ टॉपिक, बिग टॉपिक. या कुछ एक्ट्स होती हैं जिसमें आपका लोकस स्टैंडी नहीं होता टू बी अ कंप्लेनेंट. राइट? तो इफ इट इज बार्ड बाय द लेजिस्लेशन, you definitely cannot get it registered, and if it is registered then it can be quashed because नहीं होना चाहिए था ऐसा. लास्ट पढ़िए.
where a criminal proceeding is manifestly attended with malafide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. In the instant case,
बस काफी है. Okay, so the last point is very important. It's very close to the case we are drafting. अब आपको ये पॉइंट समझ में आ गए. इस जजमेंट को अपनी बाइबल समझ के 482 ड्राफ्ट कीजिएगा. अब I go back and share the petition screen again. All right, so what here is, अब इसमें से once you have your factual matrix, now you need to open भजन लाल, और आप भजन लाल को देखोगे कि आपका, अच्छा क्या मैं मेरे सारे कॉग्निजेबल ऑफेंसेस हैं? हाँ, मेरे कॉग्निजेबल ऑफेंसेस हैं. क्या allegations mentioned in the FIR lead to criminal intimidation? अब 506 की इंटरप्रिटेशन कहती है कि इट शुड रेज एन अलार्म. अब आपने किसी को धमकाया बोल के कि कान पे आपने बंदूक रख दी, तुम ये करो नहीं तो मैं तुम्हें गोली मार दूंगा, एंड ही वाज obliged to do it, is criminal intimidation. अब आपने किसी को ऐसी बोल दिया कि मैं तेरे को जान से मार दूंगा, that's not criminal intimidation. तो और पुलिस ने लिख दिया जान से मार दूंगा, तेरे अगेंस्ट 506 इन्वोक हो गई, है ना? तो अब अगर दिस इज द सेंटेंस व्हिच इज मेंशन्ड इन द एफआईआर और पुलिस ने 506 लगा दी है, तो आप 506 हटवा सकते हो ना. तो मेरे पास ऐसी कोई चीज थी जिसकी वजह से मैं तेरे को क्रिमिनली इंटिमिडेट कर सकता था ना, तूने सब्सिक्वेंटली ऐसा कोई काम किया ना, कोई अलार्म रेज हुआ, सो ऑन एंड सो फोर्थ. दिस इज बकवास. 506 नहीं इन्वोक हो रही, समझ गए? तो अब how do you use Bhajanlal in order to draft your petition? This is how what you do. अगर आप इस petition को देखोगे तो मैंने first, I'm not going to go into the factual matrix detail because all I have is 15 minutes. First point पे क्या है? Because the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. So whatever I had in my factual matrix, I have repeated it here. कि देखो CCTV footage में कहीं भी कोई मारपीट नहीं है. So if evidence is even taken on the prima facie value, it does not lead to cognizable offense. Not even a single eyewitness statement has been recorded. अब मैकडॉनल्ड्स में मारपिटाई हो रही है, वहां कम से कम 50 लोग तो प्रेजेंट होंगे ना. किसी की तो स्टेटमेंट लेके आती पुलिस? नहीं लेके आई, बिकॉज इट वाज एन आफ्टर थॉट. अब MLC भी जो है वो भी बोल रहे हैं कि कोई मार्क्स नहीं है, ब्रूजेस नहीं है, कोई स्वेलिंग नहीं है. अब अगर मार पिटाई हुई होती तो कुछ तो होता. पर्सन हु इज allegedly saved the child from the petitioner because the FIR says कि एक अंकल ने मुझे बचाया मेरे पापा से. अब पुलिस ने उसकी भी स्टेटमेंट नहीं रिकॉर्ड करी भाई, तो झूठ है ना. What was stopping you from recording the statement of the uncle who saved the child? तुम उसको ढूंढ के लाते. तुमने वो भी नहीं समझा क्योंकि तुम बकवास कर रहे हो. That the only probable witness who had allegedly saved the minor's son from the petitioner is not even seen in the entire footage. So there is a contradiction in the statement of the child and the CCTV footage. क्योंकि पूरी की पूरी CCTV footage में जब हमने उसको स्क्रूटनाइज किया तो अंकल तो दिख ही नहीं रहे हैं बचाते हुए, क्योंकि कोई पहले तो कोई मारपिटाई नहीं हुई है, फिर हमें अंकल भी नहीं दिख रहे हैं. तो ये प्रोसिक्यूशन का केस जो है बिल्कुल बकवास है. अब गोइंग बैक टू द पॉइंट, evidence collected in support of the same do not disclose any commission of the offense as alleged. This is I'm talking about after the evidence is being collected. I'm not even talking about the FIR, prima facie. Understood? Okay. आगे second point पे चलते हैं. Allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach just conclusion. तो अब मैंने भजनलाल में से ये पॉइंट देखा, मेरे केस में फिट होता है, मैंने उसको यहाँ पे फिट कर दिया. इम्प्रॉबेबल क्यों है? अब मुझे अपना दिमाग लगा के बताना है कोर्ट को कि भाई जैम पैक मैकडॉनल्ड्स था, सैटरडे आफ्टरनून हो रही है, बहुत सारे लोग होते हैं, बहुत सारे लव बर्ड्स वहां पे बैठे होते हैं, इनके पास पैसे नहीं है, वो 100 रुपए का हैप्पी मील खाने आते हैं. इन दैट जैम पैक्ड मैकडॉनल्ड्स अगर बाप उसको मार रहा है तो कोई वीडियो बनाता, कोई तमाशा देखता, कोई चिल्लाता, कोई पुलिस बुलाता, कुछ नहीं हुआ. इट्स हाईली इम्प्रॉबेबल दैट इट कुड हैपन. इट्स लाइक क्लेमिंग कि मैंने कैनॉट प्लेस के दोपहर को 12 बजे मेरा रेप हो गया पालिका बाजार के ऊपर. इट्स नॉट पॉसिबल. चाइल्ड डज नॉट मेंशन अबाउट एन अननोन अंकल. अब चाइल्ड जो है वो अननोन अंकल के बारे में बताता भी नहीं है कि कौन है अंकल. जब उसको बचा के चले जाते हैं तो वो उसने हैंडओवर भी नहीं करी कस्टडी, क्योंकि यार अंकल उसको बचा रहे थे तो कस्टडी ले लेते बच्चे की, किसी को बुलाते, ऐसा कुछ भी नहीं हुआ. पेटिशनर जो है वो बायोलॉजिकल फादर है, वो 6 घंटे ट्रैवल करके आता है दूसरे शहर से अपने बच्चे से मिलने, तो उसको 2 घंटे में मार पिटाई करने तो आ नहीं रहा, वो भी पब्लिक प्लेस. So what I'm trying to tell the court is कि look, these allegations are highly improbable. ये हो नहीं सकती हैं रियल लाइफ में. फिर आगे बढ़िए. अब क्या है कि तो मेरा पूरा फैक्चुअल मैट्रिक्स था ना, it was revolving around the malicious prosecution and the vendetta of the wife. अब मैं उस पॉइंट को यहाँ पे लेके आऊंगा. That the entire criminal proceedings is manifestly attended with a mala fide and where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused with view to spite him due to private and personal grudge. There is an ulterior motive. My lord, clearly there is an ulterior motive. I've given you the entire factual matrix. There is an ulterior motive and I am reiterating that ulterior motive. Ulterior motive क्या है? किसी तरह से मैं इसकी custody रुकवा दूं. I can go to damn extent to stop this custody from happening. मैं पूरी की पूरी टाइमलाइन बता रहा हूँ यहाँ पे. 24/11 को कस्टडी मिली, 14/9 को सॉरी फाइल हुई, 14/9 को विजिटेशन के ऑर्डर्स हुए, 9/10 को फर्स्ट किडनैपिंग की कंप्लेंट फाइल करेगी अगेंस्ट माय फ्रेंड हु वाज अकम्पनिंग मी, 27/10 को दूसरी कंप्लेंट फाइल करी गई अगेंस्ट द फादर ऑफ अनदर माइनर चाइल्ड हु वाज जस्ट टॉकिंग टू मी एंड माय सन. 14/11 को शी वेंट, मेरे को एक नोटिस आ गया पुलिस से इस किडनैपिंग वाले इंसिडेंट्स में. 13/11 को सॉरी फर्स्ट किडनैपिंग के बाद मेरे को नोटिस आ गया, फिर 13/11 को दूसरे में मेरे दोस्त जो फादर आया था उसके अगेंस्ट उसने कंप्लेंट फाइल करी, फादर ब्ला ब्ला ब्ला. उसके बाद इसने हाई कोर्ट में 227 में गई, फैमिली कोर्ट ने ऑर्डर पास किया. उसके बाद इसने अप्रैल से मई के महीने में कांस्टेबल्स को भेजा जिनका नाम ये और ये है. उसके बाद 14/5 को जब मैं गया तो मेरे बेटे ने ऐसा ऐसा बिहेव किया. उसके बाद furthermore so on and so forth. I am going to give the entire narration and convince my lords. इतना कुछ हर महीने कर रही है, वो चैन से नहीं बैठी है. And even the courts know this. The family court very well knows this. अगर कुछ भी गड़बड़ होती तो वो मेरे अगेंस्ट ऑर्डर पास कर देते, बट उन्होंने मेरी विजिटेशन आज तक नहीं हटाई है. There is a principal judge who's sitting there and observing everything down. Please listen to his observations. Magistrate has applied his mind while giving me the bail in the same case. So on and so forth. मैंने पूरा factual matrix इस ground में repeat कर दिया in order for me to prove the mala fides. हो गया मेरा point. फिर allegations made in the FIR, even if they're taken at the face value, accepted in the entirety, do not prima facie constitute any offense of make house contains. अब इसमें से आप क्या देखोगे, उसने बोला 506 के लिए, अभी तक तो हम जेजे एक्ट की 75 की बात कर रहे थे कि माइनर के साथ मारपिटाई हुई है. 506 में क्या हुआ, क्रिमिनल इंटिमिडेशन हुई. तो अब क्या एलिगेशन है कि मैं तेरे को, मेरी बात नहीं मानेगा तो मैं तेरे को छत से उठा के फेंक दूंगा. सो ना तो उसको अलार्म रेज हुआ, ना फादर ने उसको कुछ करने के लिए बोला जिसकी वजह से अलार्म रेज हो गया और करने के लिए बोला और उसने कर दिया. करेक्ट. तो वी आर सबमिटिंग की 506 नहीं बनती है. And then we file certain judgments if you want to. जहां सुप्रीम कोर्ट ने 506 की इंटरप्रिटेशन की बात कर रखी है. अब फिर हम बोल रहे हैं कि अरनेश कुमार वर्सेस स्टेट ऑफ बिहार में डीके बासु में 41A के नोटिस पे हम बात ले आए कि इस पूरे केस में 41A का नोटिस नहीं इशू हुआ था. दैट मीन्स पुलिस had some mala fide intentions. If it was a genuine FIR, पुलिस इतना तैयारी करके नहीं आती है. तो वेट कर रही थी तो किस कोर्ट डेट पे आएगा, हम सिविलियंस में आएंगे, हम तेरे को अरेस्ट करेंगे, हम तेरे को कस्टडी में लेंगे, हम तेरे साथ मारपिटाई करेंगे. ये सब प्री प्लान था. फिर हमने मैजिस्ट्रेट के रिमार्क्स रिट्रिएट कर दिए. फिर हमने बोला कोर्ट को कि जब ये सिविल कोर्ट से डिजायर्ड रिजल्ट नहीं ले पाई तो इसने इन फ्रस्ट्रेशन इन कल्यूजन विद सेक्टर 8 पुलिस ये FIR दर्ज कराई. CCTV फुटेज जो है वो पुलिस की पावर इन पोजेशन में थी FIR दर्ज होने से पहले, which is bad in law. There is nothing in the charge sheet which compelled the police in order to procure the CCTV footage from McDonald's much before registration of FIR. वो भी उन्होंने मेंशन नहीं कर रखा. concerned police stations do not have the territorial jurisdiction. Interestingly, दूसरे सेक्टर की FIR है और FIR रजिस्टर हो रही है दूसरे सेक्टर में, that means police मिली हुई है वाइफ से, so and so forth. That the FIR has been lodged within the territorial jurisdiction of this honorable court, therefore honorable court has original territorial jurisdiction to try, entertain and decide the present petition. Has not been no filed. ये हम statutory clauses लिखते हैं कुछ, ये आपके पास petition की copy है. Cause the impugned charge sheet, इसमें हमने एक point और add करना था, cause the impugned FIR dated so and so, or the impugned charge sheet so and so, and process issued by the first class magistrate so and so. ये 3 points हम मांगते हैं, फिर any other relief. ठीक है, इस तरह से आपको भजनलाल उठाना है, अपनी FIR चलान को उठाना है, फैक्चुअल मैट्रिक्स लिखना है, उसके बाद देखना है कि क्या ये कॉग्निजेबल ऑफेंस की कैटेगरी में जो इंटरप्रिटेशन हुई है उसमें फॉल कर रही है, नॉन कॉग्निजेबल ऑफेंस है, प्राइमा फेसाई इंग्रेडिएंट्स बच रहे हैं नहीं बच रहे हैं, so on and so forth. Based on all of that, आपका पिटिशन ड्राफ्ट हो जाएगा. ठीक है, दिस इज प्रिसाइजली हाउ यू ड्राफ्ट अ क्वॉशिंग पिटिशन. अगर आप इसको लेके चलोगे भजनलाल को, पहले सारा फैक्चुअल मैट्रिक्स बना लिया, तो आपको बिल्कुल भी प्रॉब्लम नहीं आएगी. ऑल यू नीड टू डू इज ट्राई टू फिट मटेरियल इन द पॉइंट्स ऑलरेडी बीन टोल्ड बाय द सुप्रीम कोर्ट. ठीक है, दैट इज द स्ट्रेट जैकेट फॉर्मूला टू ड्राफ्ट 482. और इट इज वेरी इजी टू कन्विंस द जज ऑल्सो, बिकॉज आप उसके कोर्ट को बता रहे हो कि लुक, आई एम फॉलोइंग इन द एम्बिट ऑफ व्हाट हैज बीन लेड डाउन बाय द सुप्रीम कोर्ट, आई एम नॉट गोइंग हेवायर. मैं आपसे फालतू की दलीलें नहीं दे रहा हूँ कि जी मेरे साथ ऐसा हो गया, जी मेरे साथ इनजस्टिस हो गया. लॉट ऑफ पीपल, व्हाट आई डू इज आई रीड दूसरों के ड्राफ्ट्स, तो वो क्या करते हैं, देखो ऑल ओवर द प्लेस, कहीं पे वो कोई पॉइंट लिख देंगे, कहीं पे वो को पॉइंट लिख देंगे, फिर उसी पॉइंट का उठा के वो नीचे दोबारा से पॉइंट लिख देंगे. डोंट डू दैट मिस्टेक. एक तो आपको आर्ग्यूमेंट्स करने में बहुत तकलीफ होगी, जज इज गोइंग टू स्टे कंफ्यूज्ड. आपका काम है जितनी ल्यूसिड तरीके से आप अपने आर्ग्यूमेंट्स रखोगे स्ट्रक्चरली, आपको बहुत आसानी होगी आर्ग्यू भी करने में, और जज को बहुत आसानी होगी पढ़ने में भी, बिकॉज उसको समझ में आ गया. दैट्स एग्जैक्टली व्हाट आई आल्सो डू इन बेल. गिव अ हेडिंग कि all my further arguments are going to fall under this heading. ठीक है, if no specific role has been assigned to me, it's a heading, it's a legal plea, and then I'm going to come back to the factual matrix. If prima facie though no allegations, तो फिर आप factual matrix में से निकाल के सब headings में आप आगे की बात रखेंगे. ठीक है, don't go haywire कि एक पॉइंट आपने इसका लिख दिया, एक पॉइंट आपने उसका लिख दिया, आपको भी नहीं समझ में आएगा और जज को भी नहीं समझ में आएगा. जितना स्ट्रक्चर में जाएंगे उतना आपको आर्ग्यू भी करने में आसान है, उतना ही आपको रिलीफ लेना आसान होगा. That's how, this is where I conclude my session, and I hope you understood. It was of some value to you, I hope. And this is where we conclude this criminal law workshop. I know it just got spread over too many days, was not intended to, but अगर आप recordings को दोबारा से सुनेंगे तो आपको बहुत सारी चीजें clear हो जाएंगी. I can spend another 1 or 2 minutes if have any question. Not many people are here anyway, so Mr. Chopra, Ms. Nandini, anybody has a, Mr. Chauhan has a question, we can take. Otherwise, we'll say bye bye.
सर ये सेशन ही कंक्लूड कर रहे हो या हम लोगों के साथ छोड़ रहे हो?
नहीं सर, सेशन कंक्लूड कर रहे हैं, आपके साथ कुछ छोड़ेंगे.
बस 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 यही है, हमारे को सब और भी कुछ सीखना है सर.
We'll do a new course. Abhi next month mein I have certain workshops in NLU Sonipat. So May month I am excusing myself, and June is off. I don't do anything. July on we might come back with a new course, most likely on A to Z of matrimonial disputes.
मैट्रिमोनियल सब क्रिमिनल में भी पेंडिंग रह गया था काफी.
हाँ सर.
Matrimonial one is required. It will include DV and everything.
That's what we're going to do. We're going to do an exhaustive matrimonial course, जिसमें आपकी सारी 498, Domestic Violence Act, 125, divorce, custody, Hindu, सब कुछ cover होगा करके कि आप, if you're defending a husband, what is your approach? If you're prosecuting like from the wife side, what should be your approach? from the trial court to Supreme Court. वो complete holistic. Huh?
Sorry, sir, do we have 2 minutes? If I may ask one question regarding 389. So 389, we've been discussing throughout 389.3, which is suspension of sentence. So I was going through 389, it said suspension of conviction also, and it is everywhere in the news regarding like Rahul Gandhi's conviction. So 389 also mentions suspension of conviction, which is conviction word is not there clearly, but since yesterday and today, since Rahul Gandhi's conviction stay has not been granted, not the sentence.
नहीं, कहाँ लिखा है suspension of conviction?
Sir, 389(1) basically, and I was going through one judgment, that is Navjot Singh Sidhu's judgment. It mentioned the grounds a person has to state, and this suspension of conviction has to be, the application has to be made to the appellate court.
Where is it written that conviction is suspended?
No, sir. One has to file an application along with suspension of sentence. Suspension of sentence is with the trial court. It's under 389(3). So conviction, suspension of conviction, because there are 2-3 cases I was going through. The judgments are there. Navjot Singh Sidhu's judgment is there, wherein the court has said there are no proper grounds mentioned in the application. In the application for suspension or conviction, wherein the person has to show that the balance of convenience lies on him. And in case the conviction is not stayed, the word is used is conviction is not stayed, he will be at a huge loss. This is something which the person, the accused has to, the ground has to be taken. And Navjot Singh Sidhu failed to prove that. That's the reason, even in today's thing, the word that is coming is suspension of conviction, not suspension of sentence. And I was going.
How would you convict the suspend the? Okay, there could be an interim stay on the conviction.
No, yes, sir. No, it's a stay wherein see what I was going through in today's judgment. This Rahul Gandhi's.
Deepak, can you share that judgment with me? I'll
do that,
to you because I have to catch a train at 8:30.
Sure, sir. Sure, sir.
Let me read and get back to you.
I'll do that, sir.
All right. So we'll do that. Thank you, Nandini.
Thank you so much,
everybody else, and hopefully I'll see you when I see you. Bye bye.
Thank you, sir.
Thank you. Bye.
Thank you, sir.